Goal here is to try and give you as much information as possible in the time we've got. So let me start with kind of an overview of what we're going to be covering. Changes in labor law, what we can expect, the impact on your business, how you can prepare a plan to minimize the impact, how it's going to affect you. Identify tools to use to prepare for current and upcoming regulations, which we're still going to get some, irrespective of the approach taken by the administration, which obviously is welcome, which is let's get rid of regulations we don't really need. And then let's review some workplace policies and procedures that are going to require some revision. But before we get into those specifics, let me kind of give you a backdrop. I've been doing this almost 45 years now. 10 years with the government and 30-some years in private practice, always representing management. And the question that I always want to ask is, why does this matter? Why does it matter to you? You're here because obviously you're interested in how it's going to affect you. But let me kind of give you the perspective from a lawyer's point of view. The workplace is the most regulated area in society. You don't go anywhere else where you have as many regulations that apply. The reason for that is because the feds regulate, the state regulates, local jurisdictions regulate, and we've seen a whole bunch of proliferation of that in the last few years. And then on top of all that, you have the overlay of the courts. And the courts, whether you believe it or not, legislate just as much. And we always have that discussion about, are they really interpreting the law, or are they rearranging the law and reinterpreting it and writing new laws as it were? And they really are in many instances. So you got those four things going on at the same time. And on top of it, we got the most litigious society in history. People will sue over everything. My son or daughter didn't get on the softball or baseball team, I'm going to sue the association. The school gave my son a flunking grade, I'm going to sue the school board. All those kinds of things. Well, you can imagine what it's like in the workplace. Roughly 25% of all pending litigation in the federal court system is work-related issues. And that hasn't changed much over the last 10 to 15 years. Then on top of all of this, if that doesn't give you enough concern, we have too many lawyers. You know how many lawyers we pump out of law schools each year? 40,000. You know how many we need? Probably 5,000 at best. The law industry peaked in about 2004. Most people don't know that. 25% of the lawyers that graduated in the last 2 years could not find jobs requiring a bar admission, meaning they're out there writing insurance policies or working for banks or some association or something, doing legal interpretation but not really practicing law. This year, for the very first time, there was a decline in the number of applications for law school for the obvious reason. If they can't find a job and they spend $100,000 getting through law school or more, you just have to start thinking about, is that the way I really want to go? I've got 3 sons, none of whom practice law. For a very good reason. I've had this discussion with each one of them. If you decide to go to law school, I will not pay for it. If you do go, I will not hire you. And if you graduate, I'm going to tell my friends not to hire you. So that's your choice. Not a single one decided to go to law school. So the area we're talking about has dramatic significance for you on a day-to-day basis. Every time you and your employees go to work, you have the potential for coming into contact with a rule or regulation that could create liability. You can insure for these kinds of things, and again, I'm going to digress a little bit, but I like to give as much information as possible. Some of you may have employment practices liability insurance. It's available. Insurance companies write it all the time, meaning you can insure for these kinds of claims to some extent. Here's the problem with that. One, the deductibles are usually so high that it's not worth the effort. They start at about $50,000 and work their way up. But more important than that, if you're willing to pay the money for that, even with that kind of a deductible, in other words, they won't cover anything until you get past that. Many times these claims get compromised, they get settled out way before you get there, so all of that expense is coming out of your pocket until they get to that $50,000 or $75,000 or $100,000. But much more important than that is punitive damage coverage. You all who know about punitive damage from liability issues. Punitive damages are damages that a court can assess or a jury can assess to punish you for your bad conduct, as it were. Punitive damages, which is what keep plaintiffs' lawyers hungering after these cases, and when you have 40,000 new ones out there all looking to sue you, you're going to have punitive damages claims in just about every case that comes up. And they can make those kinds of claims. And all these are jury claims. Every last employment case that goes to court can ultimately end up, if it's litigated, in front of a jury. We all know what juries will do. You are not a favored defendant. Employers are not, just like anybody else. My job, if I'm on the other side, is to get people like you off the jury pool. And I can knock out as many as 5 in some time. So I want to get a jury of employees because I'm suing the company. That's what plaintiff lawyers look at. So employment practice liability insurance is something you might want to look into, but read your policy very carefully. And the first question you should ask, does this cover punitive damages? Here's a case in point where punitive damages is important. You know that the juries run away with these kinds of cases and grant all kinds of millions of dollars. That was a case 2 years ago now in California. Of course, California, we all know, is absolutely bonkers when it comes to these kinds of issues and a lot of other things. But when it comes to labor and employment law, they're just off the charts. A single claim of sexual harassment involving a hospital chain, an administrator in the hospital chain, an employee claimed that she was being sexually harassed, and there was nothing salacious about it. It was put the arm around the shoulder, and those repeated conduct over a period of time that she complained about finally ended up in a lawsuit. The punitive damages in that case, well, let me ask, what do you think that's worth? What would you guess? Anybody? $9 million. Piker? Anybody else? $248 million. It broke the hospital chain. They went bankrupt. That's how crazy these cases become. You're talking about millions of dollars on the hook. Just imagine how serious these kind of cases can get. That's the backdrop that we're operating in. So I do that not to scare you, but just to tell you how serious these issues are and why it's so great that we're moving into an administration that's going to be more employer friendly. This is not a political statement, but it's a political fact of life that under a Democratic administration, you're going to get a pro-labor, pro-employee, as it were, approach to the enforcement of labor and employment laws. Under Republican administration, vice versa, you get a pro-employee, pro-employer approach, kind of like if you were here for Courtney's presentation this morning, he talked about a business approach. The agencies are being peopled at the top levels anyway by people with a business background, that drain the swamp mantra that we've talked about. That's where it really starts, is getting rid of people in these executive positions that have a much more friendly business approach. So that's what we're trying to do. But the problem is that we're going very, very slow. When this administration came in, those of us who practice on the management side were hopeful, and we think with good reason, that we were going to see a change in the approach to enforcement and the regulatory process. So we're going to slow down regulations, we're going to slow down enforcement, we're going to have, as we say, a more pro-employer approach. Problem is that we have not been able, for a variety of reasons, to get nearly as many of the executive level positions appointed and confirmed as we need. So we're going to stay in this Obama era pro-labor, pro-employee mentality for an indefinite period of time. Courtney used an example in OSHA that there's the silica rule change has been pushed back until September the 23rd for a reason. He and I agree on the reason. It's probably because we're not going to see the Assistant Secretary of OSHA in the Department of Labor until probably September. And that's not unusual. Of the executive level positions, there are about 550 of those that people at various agencies in this country. As of last week, only 155 have been appointed and put in place. That means that going forward, at least for the indefinite future, we're living under a Democratic administration, as it were, so that the rules that we're going to live by are going to be those that were adopted during the Obama years, and the people that are enforcing them are going to be people that have that same kind of mentality. So enforcement can continue. I don't know how long it's going to go, but it may well be through the end of this year, and maybe even the beginning of next year. When you've got 400 plus people that you need to get appointed, and you have a process in the Senate for some of these people that require Senate confirmation, that they're all being slowed down. There's a rule, some of you are probably familiar with this, that the party out of power, or anybody actually in the Senate, can demand 30 hours of debate on any presidential appointment. Well, Chuck Schumer is doing exactly that. He's demanding 30 hours of debate on every candidate that goes up. So not only is they slowing down the process at the committee level, but they're also, when they hit the floor of the Senate, they're just taking their 30 hours. And so you're talking about, as infrequently as the Senate sits, how long is it going to take to work your way through these 400 or so people that need to go through that process? So the kind of changes we were expecting are, even though we're going to have enforcement, there's going to be more outreach. And I think that if you were here at Courtney's presentation, he talked about at the very end of that, a more pro-employer, pro-cooperation kind of agenda from OSHA. Well, that's going to be true of most of the federal agencies when we get there. We're going to have the end of the gotcha mentality. During the Obama years, all 8 years of the enforcement process of these federal agencies, and I'll talk about the specific ones in just a moment, the mentality of, at least out in the field, and probably all obviously came down from Washington, was let's get the employer, let's use fines as a way to punish them. And in fact, there was a whole lot of debate about what they were doing with the money. Some of you may have read this, and I know I saw this in the Wall Street Journal not too long ago, that some of the fines that were being assessed and also the settlements that were reached were being funneled to pro-democratic associations and groups, because that was something that the president had discretion to do, and so they did it. It's not illegal. It's just a process of saying we're going to take the government money and redistribute it to people over here that, in our opinion, need it for whatever purposes, and sometimes they're political purposes. But it's perfectly legal, and both sides probably do it. And then we're going to probably get more employer-friendly decisions, and there's going to be more room for settlement. This is what we're working towards whenever we get there. Alex Acosta is the Secretary of Labor. He was just appointed in May. There are very few, as I mentioned, OSHA has not been named, the Assistant Secretary there. Likewise, the undersecretaries of all these various administrations within the Department of Labor have not been appointed. So no new policy is coming down. We're still living under that old policy. The head of the EEOC is that agency, some of you may be familiar with it, Equal Employment Opportunity Commission. They have jurisdiction over all discrimination laws at the federal level. The chairman who was just named hasn't been confirmed yet. That means the commission, which she will be the head of, is still the Obama-appointed commission. So you know the direction that enforcement is going to be in terms of our discrimination laws. And I'll talk about a couple of the other agencies in a few minutes. We have had some minor victories. I think, as Courtney said, there's been some effort to turn over or stop regulations in their tracks. Here's a couple of them or several of them that have obviously stopped in their tracks. Some of them because of court action, some of them because of the executive orders that have come down from Trump at the very beginning, within the first few weeks of the administration. Persuader rule, you probably have never heard of the persuader rule. If you're a non-union employer, it should be important to you. The persuader rule is a rule that has existed in the Department of Labor for many, many years, rarely ever enforced. Under the Obama administration, Secretary Tom Perez, who was Secretary of Labor, decided to put some teeth in the rule. The rule essentially says that if somebody is talking to your employees or assisting you in keeping a union out, and they directly deal with the employees, they're a, quote, persuader. And if they do that, then they're obligated to file certain reports. Tom Perez, former Secretary of Labor's interpretation of that rule to put teeth in it was to say that from now on, and this happened about 2 years ago, from now on, as of that date, if anybody, lawyers or otherwise, assist a company in keeping a union out, they will have to file a financial report that's subject to public disclosure for all of their clients, for all of the work they do, not just for that particular client. Virtually every law firm that I know that represents employers like we do said, we may have to get out of the business because the last thing I'm going to do is publicize what we charge our clients and what we've received from our clients, because the clients don't want that. That's privileged information, et cetera. They ignored that. Bar Association sued over this rule, saying what you're doing is requiring law firms to disclose privileged information. The court never really got to the case. It was still pending. That was a persuader rule. This administration, one of the very first executive orders said, we're not going to enforce it that way. We're going to go back to the way it was. It's only going to happen when a lawyer actually is out there talking to employees, and we're not going to require these extensive financial reports that they're required to file. It was something, when it was passed, they were talking about if I were to come and talk to your supervisors about here's what you would see in a union organizing campaign, that was reportable conduct, which has never been. I've been 40 years I've been doing this. That was never required, but that was what the rule was going to do. The joint employer rule, here I'm talking about strictly the Department of Labor. You've heard talk about joint employers being a big issue, and I'll talk about it a little more. This was another effort to try and expand the liability so that you could get two companies at one time. If you have other employers working on your premises, if you're jointly working on something, it started with the NLRB, it spread to the Department of Labor. And the Department of Labor's interpretation, done again by a directive or a bulletin that essentially was saying this is just an interpretation of existing law. So it wasn't an order from the court or not a new regulation. They said if two companies share the same workforce in the sense that you have staffing companies, you have somebody else on your premises, under certain circumstances, we're going to hold you responsible. For example, if the independent contractor you have working with you didn't pay the proper wages or didn't pay the proper taxes or didn't deduct for their employees, you could be on the hook for it. That rule was also overturned by this administration. That was one of the first things that the new Secretary of Labor did about a month and a half ago. And then lastly, the overtime rule. We all know that there was going to be a dramatic change from the current 23,660 to 50,440. That was going to affect, according to the government, that was going to affect about 5 million people. Between us, we're talking about probably 12 to 15 million people that were going to be affected that would now be eligible for overtime. That's what we're talking about, exempt from overtime purposes. 23 obviously is very, very low. 50 was way over the top. We'll talk a little bit as to whether this is going to change or not. This was stopped by court action, and then on top of that, Department of Labor said, we're withdrawing it. Now, it's still out there as a rule. One of the problems, and Courtney alluded to this, when there is a regulation issued by an executive agency, to get it off the books, they have to go through exact reverse process. They've got to post a notice, they've got to publish the regulation that they're intending to nullify, and then put it out for comment for 60 days, and then come back and go through that entire process. It's very, very cumbersome and takes a long time, and it's very, very difficult. That's why the Obama administration agencies were using directives and different compliance memos to use that to say, this is our interpretation. It's not a regulation, so you can't sue about it. So here's how we're going to apply the law. So those were kind of victories that we've had as the administration's changed. Let's talk about the changes to me that are some of the most dramatic. National Labor Relations, anybody here unionized? A couple of you. Those that are non-union, pay attention, please. National Labor Relations Board, I worked for them both in Washington and out in the field for a number of years. National Labor Relations Board is a federal agency. It governs relations between unions and the company and between employees and the company. Most people don't realize that it has jurisdiction over non-union employers. It isn't just unionized employers. This administration, or the Obama administration, expanded that area of non-union employers absolutely dramatically, so there's all kinds of changes that took place. The Obama approach, obviously, for very good reason. Organized labor, obviously, is one of the strongest supporters of the Democratic Party. They spent over $400 million in the last election cycle, 2016, and we are usually in that same range for the Obama election 2008. They spent about that same, I think it was slightly more than that, it was almost $500 million, all coming from different unions throughout the country. They were buying influence. That's what the dollars do. The NLRB, because of their approach towards supporting organized labor during the Obama years, is still in place. Right now, it's a 5-member board appointed by the president. There are currently 3 members. 2 are Democrats, 1 is Republican. The Republican has been appointed the chairman. They are labor lawyers. The chairman is a management labor lawyer like I am. The other 2 are union lawyers. The 2 additional ones have been named, but they haven't been confirmed yet, and I don't know when they'll be confirmed, probably the end of the year. The general counsel for the NLRB, the chief lawyer that makes the day-to-day rules and enforcement policy, is still the Obama appointee. He is obviously favorable to labor. So we're not going to see many changes at the NLRB, and we'll talk about some of the things that they've had in just a moment. We're not going to see any changes there for, I don't know. End of the year, beginning of next year, maybe even the middle of next year, if not longer, because some of these things require cases to come before the agency before they can change the rule. The quickie election rule, some of you may have heard this. Way back at the beginning of the Obama administration, you all remember the card check rule. The card check that we're trying to do was going to try and get it through Congress, basically saying that if your employees, a majority of your employees signed authorization cards, you would be compelled to recognize the union without a secret ballot election like the current process requires. That was called the Employee Free Choice Act. It got killed in Congress. There was all kinds of opposition, obviously, from business groups, and ultimately it died. But that was one of the biggest concerns that we had as management lawyers when the new administration came in the Obama years. That was part of what they wanted, was that kind of an approach. So what they did, instead of passing that act, they used the internal process of the NLRB because it now favors organized labor. So they adopted the quickie election rule. Normally, when a union is organizing a company, they file a petition. It takes about 45 days to get to that election. In that 45-day period, you're permitted to educate your employees about what a union means or doesn't mean to the company. Well, obviously, if you educate your employees, most of the time they're not going to vote for a union, especially today when most employees have no clue what a union is all about because unions are down to 6.4% of the private workforce. So a lot of employees in today's have never known about a union. Their parents may not have known about a union. So educating them about it is very, very critical. Well, if you shrink down that time to 14 days, which is what the rule did, you get a petition and you have an election within 14 days. Can you educate your workforce effectively in a 14-day period? In most instances, not. And the larger your workforce, obviously, the more difficult it becomes. So that was a very, very critical change. That's still in place. Unions are winning about 60% of the elections that are held in this country because of this rule. They're being held, the elections are being held on average about 20 days, even though they can go down to 14 days. And the NLRB pushes for 14 days. And then specialty health care and micro-bargaining units. Historically, the collective bargaining unit that a union would try and organize for the last, since 1935 when the act was passed, was all of the employees in your workforce that were either production or maintenance employees formed one unit. They had a community of interest. So if it's 10, 20, 100, that was a group. The micro unit rule under specialty health care, that's the name of the case, said if the union decides to organize a small group of your company, that's going to be permissible. Doesn't matter how small that group is, as long as it's more than 2, they can organize that group. You got 5 maintenance guys working over here, and they're essentially all working together, and even though they're all part of the bigger group, the union can select those 5 and say, we're going to organize those. So they can organize those, get an election, and you're stuck. You've got a union representing those 5 employees, and you have little or nothing to do about it because it's permissible under the law. That was a major change. Again, keep in mind, all of these changes are being made in order to support organized labor because that's obviously the mentality of most Democratic administrations. It isn't just Obama, it goes back years. That's always been the case. So when we talk about these changes, those are a couple of the more significant ones. Let's talk about a couple more. Purple Communications, another case. Historically, until this case about 4 years ago, and remember, the cases are decided by the board in Washington. 3 on one side in a Democratic administration, 3 Democrats. We will have ultimately 3 Republicans. And so you know when and they're always decided by a board of 3. Usually 2 from the majority, 1 from the minority. So you got 2 Democrats and 1 Republican deciding these cases. Purple Communications changed another rule, again, to support union organizing. Historically, if you had an email system in your operation, which everybody does, it belonged to you. You could prevent employees from using it for personal purposes, for organizing, for any other kinds of things. You may have permitted some of those kinds of things, and they probably go on whether you permit it or not. I think most workplaces are that way. Well, under this rule, what they said was, it doesn't matter that the employer owns it. He cannot prevent employees from utilizing the email process within that company. If they have email available for work, they can use the email process to organize a union. In other words, they can essentially conduct an electronic campaign. That's never been true before. Again, that's an absolutely significant change, especially in the kind of environment that we live in today where everybody's on email and all the communications are on email. The old historic way of unions organizing where they hung out, where the employees go after work to a local watering hole or park or a softball team or whatever and trying to get people's attention or hanging out the front of your gate. That's no longer the case. They're using email because they can find a sympathetic employee and that employee can infect your entire system simply because they're permitted to do it. So that's another significant change. These are all pro-union rules that cannot be changed until these cases come before the NLRB. That means they got a case that works its way up from the regional offices, it's decided by administrative law judge, it's appealed, and gets before the board. So we're talking about possibly 2 to 3 years before some of these rules change. So as much as I would love to believe that we're going to see a dramatic change in the way labor and employment laws are enforced in this country, it's not likely to come in any time soon. Again, the numbers there you can see were a total of 6.4% of the private workforce. That's why I say today very, very few employees really know about unions. You've got to be in a pro-union state, New York, California, places like that where people are accustomed to dealing with unions. So you really do need to educate your employees. Let's talk about minimum wage and leave time. Make sure I don't run out of time here. Oh, we got plenty of time. Minimum wage. Everybody knows that we've had a whole kind of discussions about minimum wage. Is this administration likely to change the minimum wage? Currently, federal minimum wage is $7.25. That's obviously way low. Most employers pay substantially more than that. Many states have mandated much higher minimum wages. Federal contractors, some of you may be federal contractors, you've been required to pay $10 plus for the last 3 years at least. We're probably not going to see a lot of pressure on the minimum wage, even though President Trump has made comments that he's favorable to it. He does believe that something around $10 is appropriate. It's possible we may get there, but we all know that there's a lot bigger fish to fry between now and then. We've got Affordable Care Act, we've got the tax revisions, we've got stimulus, we've got all those kinds of issues, and these kinds of issues are really way down on the totem pole in terms of getting any kind of attention. And more importantly, the states have stepped in. The states and local agencies and cities have stepped in and are picking up the minimum wage. So the likelihood of a minimum wage change is probably slim at the federal level. But we're not just limited to those. This is another one where I think we're going to see some movement. Currently, unless it's at your state that's mandated some type of a paid leave, and I'll talk about those in just a minute, most employers, if you have 50 or more employees, you're subject to the Family and Medical Leave Act, which was passed in the Clinton administration in 1994. And that, if you have 50 or more employees, requires you to provide up to 12 weeks in a year period of unpaid leave to your employees. You can make it paid if you want. Some states and some employers have some segments of it paid, and sometimes it's part of a paid time off program. But in other words, no one at the federal level has forced employers to have paid leave. This is the first time we've talked about it. Ivanka Trump has talked about it. President Trump has commented favorably, saying, yeah, he's in favor of it. We're not clear what the details are yet. We don't know who's going to be covered. We don't know what size the employer. Keep in mind, most federal regulations, you have to be of a certain size to be covered. 15 employees for the discrimination laws, 20 employees for the Fair Labor Standards Act, 50 employees for Family and Medical Leave Act. NLRB is the only thing that's different. You got one or more employees. If you got 2 employees, more than one, you're covered under the National Labor Relations Act. It's going to be only for the birth or adoption of a child, meaning it's not going to be for personal illness like family and medical leave is, or a family member's illness. But again, we don't have the details. And it's going to operate something like unemployment insurance, operate at about that level. About 66 2/3 or so of their pay would be what they would receive, at least the way it's being talked about. Again, very, very few details. The problem with this is, at the federal level, is that there's been a movement across the country from a lot of people trying to get Family and Medical Leave Act paid. Not only to reduce it from 50 employees, but down to 25 employees and make it paid at some level. We'll talk about what the states are doing in just a moment. Problem with it coming at the federal level is that it's the old camel's nose under the tent. It'll just keep expanding and expanding and expanding. And at some point, it's going to be full pay for probably up to 12 weeks like the FMLA is. I don't know when we're going to get there. And it's probably not going to happen in a Republican administration, but if we have another administration that's got the pro-labor leanings and the pro-employee leanings that we had in Obama and somewhat in the Clinton years, we are going to see this happen. My prediction is if we see this in this administration, we won't see it till probably the 2020 election cycle, because if you have the Democrat approach, which has been true the last elections, of the war on women theme, this is a perfect response to the war on women, and I think that's probably when we'll see it, if in fact that happens. Again, that's kind of a prediction, but and I think that's probably a fairly safe one. So local and state action phenomenon. Obviously, state level, state and local aid groups have now, the state, the cities, et cetera, have all jumped in. They've always had laws that apply to wages in California, for example, New York, for example. They control when breaks are taken, they control what the length of the day is, and those kinds of things. This is all new, and this is new within the last several years. So we're talking about, the Fight for 15, which started in Seattle, is now spread throughout the country, meaning that we're going to go to a $15 minimum wage in increments. Right now, they're moving up. By 2019, I believe in Seattle, it's going to hit $15. A lot of other cities have adopted this. A lot of states are doing the same kinds of things. There you talk about paid family leave. You have California, New Jersey, Rhode Island, New York have all adopted paid family leave at some level. We're going to see more of that. It's coming. It's coming within this administration. When the Fed quits regulating, the states jump in. It's a modern day phenomenon we can't change. But it means, one of the things that it means for you, though, is you need to stay engaged at the local level. We've always relied upon federal lobbying and federal associations dealing at the federal level. Today, it's probably a lot more important to deal at the local level. We've got an administration that says we're going to do our best to keep regulation down. The states are not going to do that. States are going to continue regulating. Cities are going to continue regulating. So get involved locally. Look at initiatives. Look at making sure you have somebody in your state capital that's looking at the legislation that's coming down the pike that affects your workplace, because that's where it's going to come from. Arizona just adopted a paid sick leave law, really strict in terms of you can't take any action against an employee that exercises their right because it's considered retaliatory. And then New York just recently passed one that takes effect in January of 2018 that's going to be paid paid by employee contributions, but it's going to be paid out at the average weekly wage. In New York, current average weekly wage is a little over $1,000. I can think of a lot of people that would sit home for $1,000 a week for as long as they possibly can. In this case, it's going to working up from 8 weeks in 2018 up to 12 weeks in 3 years. Okay, make sure I want to cover all these issues that we've got time for. They told me I can go a little bit over 11:15 if I do it carefully. Drug tests in the workplace, medical marijuana. Question came up in the last session about there's this tremendous conflict. We've got recreational marijuana or medical marijuana passed by you. You see the number of states that have it. It does create a major conflict for a whole lot of reasons. You can see the states that have recreational marijuana. Some of those just adopted. Nevada just in January of this year. Maine just in January of this year as well. The other ones have had it for a period of time in terms of recreational. The medical marijuana issue, until last week, there had not been a single case in the country where an employer who terminated an employee because they tested positive for marijuana and they had a drug testing policy was held accountable. In other words, was found that he should not have terminated that employee. In other words, we got to pass on it because we had a drug policy, because marijuana is considered a controlled substance under federal law, and everybody knows that. Not likely to change under this administration. I had grave concerns about going forward if we had another Democratic administration, because there was a lot of talk about taking marijuana off of that list because of this whole idea that it's, quote, medicine. So a lot of people self-medicating out there on a regular basis. And unfortunately, I don't think that's going to change. Now, when I say until last week, Massachusetts was the first state last week that had a medical marijuana case where an employee was not hired or was terminated after they'd been hired because they tested positive. Now, some of the analysis of it, I kind of disagree with. I've read quite a few articles about it. A lot of lawyers are saying, well, it's because of the unique language in there. What I think some of the people are missing is that the court pointed out that in all the other cases litigated in the country that found the employer had the right to terminate somebody, the employee had not raised a claim of disability. In Massachusetts, the employee won at least the case gets to go forward because the employee there said, I take the marijuana for medicinal purposes or medical purposes. I've got the state card, and my condition, Crohn's disease, is a disability under the law, state law and federal law both. To me, that's a signal to every other state that's got medical marijuana. We're going to start seeing this claim. They're going to say, because I'm disabled, I should be permitted to have marijuana in my system, even if I test positive at work. Major concern. I don't know how soon it's going to take us to get there. It'll be a while, year or two, but down the road, we're going to see that argument made. Very few people have picked up on that footnote. A lot of times, the law is decided by the footnotes that the judges write. That footnote has significance. I'm not sure why people haven't picked up on it, but anyway, that's my prediction on medical marijuana. Courtney talked about this a little bit. The only addition that I will make is that trying to show impairment at the time that somebody is actually injured or causes an accident in the workplace is extremely difficult. There are no tests out there of any kind that can show actual impairment at the time. They can show they had the presence in their system. The closest you can come is a saliva test, which can show that someone took a banned substance within 4 hours, whether it's marijuana or something else. That's the closest we're going to come. And I suggest you might want to talk with your drug testing agency, whoever you use, to find out how expensive saliva testing can be. It's probably the most accurate. It's the one most likely to show that someone was actually impaired when an accident did occur. So just keep that in mind. Unfortunately, I think we're going to have this issue for a long period of time. And I agree exactly with what Courtney said. If you have a policy that says you're going to be tested, continue to do that. Let them try and prove that we're wrong in doing it, especially in a safety-sensitive job. And that's another consideration that I wanted to throw out. The reason I even go to this is the court made reference to, quote, safety-sensitive jobs. They talked about DOT rules, et cetera. There's no downside to designating jobs in your workplace, especially those that are considered safety-sensitive, and obviously a lot of the things that you do are. Call them safety-sensitive. In the job description, describe them as safety-sensitive. It may buy you something. I've read cases where the court relied upon that. They said, well, this is a safety-sensitive job, so we can hold that employee accountable because he's engaging in conduct that's banned by the employer. So consider that when you go back, and then obviously talk to your testing agency about saliva testing. Here's a bigger problem. Prescription drugs in the workplace. How many people take medication? How many people have prescriptions here? Don't ask. Don't answer me. But I'm the same way. How many of your employees are taking medication? We have an opioid epidemic in this country. We know it's gotten totally out of hand. $65 million in the new revisions to the Affordable Care Act are designated for dealing with opioid addiction. Obviously, it's a major problem. Unfortunately, during the last administration, and again, we don't know how these directives, and again, it was done by way of directive, not a rule. EEOC took the position that you could not test somebody automatically simply because they had a opioid or some prescription drug in their system. Worse yet, you couldn't even require them to let you know when they had a prescription for those drugs and they were taking it. And when we talk about this drug, it's absolutely shocking to me. When you, on those labels, take a look if you've taken any kind of an opiate or one of those kinds of heavy drugs for pain or things like that, it's going to say right on the label, do not take this medication if you're driving a car or operating, machinery. Obviously, that means something. EEOC took the position, well, we don't care. Unless, because that person may have a disability, you have an obligation to reasonably accommodate the use of that medication in your workplace. And I've had 3 cases like this in the last 2 years where we had to defend the company against that whole issue where they said, well, we don't care that employee is taking a prescribed drug that causes them to be impaired in the workplace. If it's prescribed, you are engaging in conduct that violates Americans with Disabilities Act. We won 2 of the cases. One of them is still pending. And again, it was in the steel industry, which was very, very, obviously very significantly safety sensitive. If somebody falls over, trips or something, they could be killed or kill somebody else. Obviously, the way the EEOC has taken the position that while you cannot compel people, they will permit you to have a policy that says, we request you to inform us of taking of any prescribed drug that could cause impaired conditions. You can put that in your policy and ask them to do it. You can't hold them accountable, you can't punish them for it, you can't discipline, but at least most employees will comply. Let them report it to your MRO, to your plant nurse or somebody. Normally not the supervisor, because the supervisor is not really supposed to know about somebody's potential disability. And then lastly, and I'll cover it in just a second, establish a relationship with some type of industrial medicine clinic if you don't already have one. Those guys can help you. They can help you in this particular area. They can also help you in any fitness for duty exams because they know your business. Have them come out to your business. Have them look at your jobs. Let them understand what someone that your employees have to do so that they can then help you in defending cases when they arise. And here's some of the practical steps. All of you should be familiar with all this. Have a policy. Make sure it's written. Make sure it's publicized. Make sure that every employee understands that we're going to have a drug testing policy irrespective of what the state law is. We don't care. We're going to enforce our policy. Make sure that employees inform you of the medications, as I just said a minute ago. Educate your supervisors about recognizing them. Here's where you can get help from your local community police agencies, police departments, different groups, sheriff's departments. Many of them have volunteers that will go out and teach your employees, your supervisors primarily, what to recognize, the signs of impairment in public and in the workplace, et cetera. They're the same. Call on them. You don't have to go spend a lot of money to get this done. It can be done because of your relationship with your police. And then consider the kind of testing you're going to have. Saliva is one that you might want to consider. Pre-employment, one of the problems with pre-employment is that in states where we have recreational marijuana now, it's becoming much more difficult to get employees that can pass a pre-employment test. I have a large employer in the state of Washington that has over 1,000 employees, and they've constantly got people interviewing. As of last month, 1 out of 10 passed the drug test. That's where we're headed, unfortunately. If you're unionized, obviously you need to collectively bargain anything you're going to be doing with this, and then establish a relationship with a local industrial medicine clinic that I mentioned. Immigration issues to finish up. Obviously, this is a high priority. We talk about it all the time, whether it's refugees, whether it's people coming across our southern border, the border wall, et cetera. Simply because of the attention focused on it by the Trump administration, we've seen a dramatic reduction in the number of crossings across the southern border, with probably the lowest in 20 years as of 2 months ago. What that means, though, is that we've got fewer immigrants out there, and we've had an impact in a lot of workplaces. It's harder to find employees. You may be having the same kind of experience. Much, much more difficult. It's only going to grow more difficult as we go forward. All kinds of jobs that are not being filled. There's going to be a renewed focus on unauthorized employees. Stopping people in the workplace is what this administration is going to try to do. It started very early on. It started when the Immigration Reform and Control Act was passed. It's going to continue and it's going to proliferate. Roughly, they put out about 1,500 notices of inspection. ICE puts them out every quarter. That means that 1,500 employers will be called upon to say, present your I-9s. Remember, you have to fill out an I-9 for every employee that you hire. And it's very important that those I-9s be fully completed. And there's a new form I'll show you in just a moment that just came out that you're going to need to start using as of September. The I-9 fines have doubled way beyond what they should be. 216 is the lowest level for a minor violation. Something as simple as somebody didn't sign or didn't fill in a date, that's a violation. That's finable. Now, 216 minimum. And when you consider the number of employees you have and all the I-9s that you have to keep for all employees, they can go through each and every one, and they will. And every one that's got a mistake on it, you will be hit with some dollar fine. There have been cases where hundreds of thousands of dollars in fines were large employers with a large number of employees. The new I-9 form, that's the website where you can download the new form that has to be used as of September. It's a violation, a technical violation, not to have the new form starting in September. Remember, you can discard the ones that you no longer need, and here's the rule. You have to keep an I-9 for 3 years from the date of hire or 1 year after the employee leaves your employment, whichever is longer. Okay? 3 years from the date of hire, 1 year after they've left, whichever is longer. Why do you want to do that? Because if you're audited on your I-9s by ICE, and remember, this is going to increase, They can fine you even on forms that you could have discarded, on employees that no longer work for you. If you have that in your records, you will be obligated to turn it over to them, and they will then look at it and fine you on somebody that's been gone for a year or 2 or 5. And sometimes we keep records way much longer than we ever should. I'm not going to get into record keeping. That's a totally different subject because the rules are all over the map. And then mandatory E-Verify may become mandatory. E-Verify is the electronic system. Some of you may be on it. This has been one of those. We're not going to see comprehensive reform, but we're very likely to see E-Verify. All employers going on to E-Verify sometime in the near future. I don't know how soon, but my expectation is that it'll be probably before this administration is over. Meaning that everybody, right now federal contractors are required to do it and certain other employers, put the name in, it comes back as to whether they're authorized to work or not, and obviously you can't hire them. It's got some problems. I don't know if they're ever going to work it out. It's not a safe harbor, in other words. That's what the big argument is, what's stopping it thus far is that Republicans have been saying, until there is a safe harbor saying, if you use it, you ought to be insulated from being fined or held liable because you had somebody unauthorized. It doesn't catch false identity. As long as there is a true Social Security number for the person that comes to work for you, then that's probably going to pass muster under E-Verify. But you're still liable for that individual if ultimately it's found that that employee was unauthorized to work. You could be found to have knowingly employed somebody. That's the problem with it. So until we iron out those problems, I don't see it passing. And then that's it. I could talk about a whole lot of other issues, but just keep in mind, we're going to have a period of time here, whenever it's a year now, 2 years. During this administration is the time you really need to focus on your employment policies. Clean up everything that you've got, because we're not going to have this low regulation at the federal level forever. Whether this administration goes on and wins another election or we end up with another Democratic administration, at some point we are going to see much more stringent enforcement, more of the gotcha mentality. To the extent that you can adopt a handbook, clean up your handbook policies, make sure you have no harassment policies, make sure you have complaint policies for employees, put all those things together and put yourself in a position to defend yourself against these kinds of cases. You heard at the beginning the kind of dollars we're talking about? Well, you don't want to be the one on the receiving end of one of those kinds of jury decisions. They can put you out of business. Thank you very much for your time and your attention.